Welcome to News with a View, hosted by me, John A. Costa. Today is January 17th, a Saturday, a rare day for me to do a podcast. This would be episode 10. And yesterday I said I would discuss the principles and some history on the 10th Amendment. I'm doing this because Attorney General of Minnesota, Keith Ellison, is attempting to use the 10th Amendment to block President Trump from issuing orders that the National Guard be sent into his state. Honestly, he doesn't stand a chance. What he's trying to do makes no sense. But let's get to the point of the 10th Amendment. The 10th Amendment, part of the original Bill of Rights, the 10 amendments, was primarily drafted by James Madison, who introduced it in Congress to reassure anti-federalists that the new federal government's power is limited and addressed already, reserving all other powers to the state or the people. Though Roger Sherman, who was a representative from Connecticut, yes, changed some wording in it that eventually was incorporated into the language of the 10th Amendment. He contributed some of its final wording, removing expressly from the Madison original proposal, because his idea was Madison was too broad of a word. So we'll get into that. James Madison's role as the architect of the Constitution and one of the 5 key members of writing and drafting the Bill of Rights and Declaration of Independence and such, Madison introduced the amendment to address concerns about federal overreach. Even back then, the colonies were very concerned about, we'll have a federal system, we'll have an oversight, but we don't want an overreach. We don't want them coming into our states and dictating to us what to do. So the response to the anti-federalists, the amendment was a response to the critiques made by federalists and critiques made by anti-federalists who feared the Constitution created a federal government with too much power. So it added to secure ratification, they added words to secure ratification by some states. The states were holding up the Bill of Rights because of this. And this is why this became the 10th. Now, I think there were originally 12 amendments that were in there, and they tossed 2 and kept this one, because this one was a catch-all of their worries about all the other amendments. While Madison proposed language, Connecticut, like I stated, Connecticut Representative Roger Sherman omitted the word expressly, allowing for a broader interpretation of implied powers, which is the wording we have today. So this is where, in the Constitution, words are very, very important, even though there are declarations made by Supreme Court justices that the words are the words. They have no other meaning than what was written and meant so that the average voter could figure out exactly what those words meant. Now, that has changed a bit over time, but if you're looking at the intent, it's there. And this is where people have problems with the 14th Amendment, just so we say. The core principle of the 10th Amendment established the principle of federalism, a governing body over the state, and stating that any powers not delegated to the federal government nor withheld from the states are reserved for the states or the people. Meaning that if there is no conflict between the Constitution, the U.S. Constitution, and state rights, at that time they were doing their own, each state was working on their own constitution. But this established that the federal constitution overshadowed state constitution. But if there was no wording in the Constitution on those first 10 amendments that the state could then make it their own language inside their state constitution. So it said if the power's not there, then the state has the right to do it, or the people. So not a state, but territories, and I mean, this is how far thinking these people were. That they looked at this and said, yeah, that's today, but what are you going to do tomorrow? So part of this was locking in the other 9 constitutional amendments and the Bill of Rights, that they are forever and can't be touched. Though we'll get into that too. This protected religious freedom. This respected a whole bunch the testing of a person's religion, and this is where I get upset when people go, he swore on the Quran, or he swore on the Jewish Bible, or he swore on a Bible. There is no religious test for office. So when people are here complaining, complain about something else, that's not a means, because if you were an atheist, you wouldn't have to do that. You wouldn't have to. You just personally swear that you will uphold the Constitution. I mean, we've had atheists. It's not uncommon. So that's the core principle, was the idea that the federal government did not have absolute power over states. States were able to make laws and a constitution as long as it was not in conflict with the United States Constitution. So, very specific. And in certain applications, state constitution could be stronger than federal constitution in its in its laws. Kind of like the Constitution is at a minimum and the state can do the maximum, but the state can't make the federal law less than what the federal law is. It the 10th Amendment qualified the federal government, but it quantified what the federal government was allowed to do. Very interesting. So the historical background of the 10th Amendment: the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. Again, like I was saying, the states have the right to address their own constitution as long as it's not in conflict with the U.S. Constitution. The 10th Amendment confirmed the understanding of the people at the time of the Constitution was adopted. That the powers not delegated to the federal government by the Constitution are reserved to the states respectively, or to the people. And two, in the sense, the amendment is merely declaratory, a truism that all is retained which has not been surrendered. Yesterday I talked about, give Caesar what is Caesar's and give God what is God's. That was the kind of sentiment that the Constitution gave the power of the federal government. But the states don't surrender to anything that is not there. The government couldn't come in and go, oh, tomorrow it's this, or this is what this means now. They couldn't just arbitrarily do that. So, the 10th Amendment was meant to be just a qualifier, a declaration, or as a truism. At the time, Justice Joseph Story characterized it as a mere affirmation of the necessary rule of interpreting the Constitution. Very powerful to say that this is just a means for us to identify what power the federal government has over the states. There's nothing in there that comes in through a back door without it going through the people. Being an instrument of limited and power, it follows irresistibility that what is not conferred is withheld and belongs to the state authorities, if invested by the Constitution of the government respectively in them, and if not so, vested is retained by the people as part of their residuary sovereignty. Again, limited and enumerated powers. That's what it's about. So, the 10th Amendment's purpose should be understood in the context of the Bill of Rights, of which it is part of. As originally drafted, the Constitution did not include a Bill of Rights, which was rejected when proposed late in the Constitutional Convention. Federalists argued that because the nation's government had limited or enumerated powers, there was no need to protect individual rights expressly. You already have that protection. We don't need to say, again, these are the sets of protection. It's already there. You have it already. Why, for instance, should it be said that liberty of the press shall not be restrained when no power is given in the Constitution by which restriction may be imposed? So, they're saying that's already we have a freedom of the press. There's nothing in there to say that we're going to restrict the press. We don't need any more language in there. You know, you're beating a dead horse here. On this view, including a list of rights in the Constitution could be dangerous because it might be misunderstood to imply that the national government had powers beyond those enumerated, meaning that, well, wait a minute. You're saying that, you know, maybe there's people in this that will be broader power. Freedom of the press. You know, what happens if it's not the press, if it's something else? What happens if it's a guy on a corner? What happens if it's in a letter? What happens then? The argument, again, including a Bill of Rights, did not persuade many states ratifying conventions. However, and several states assented to the Constitution on the understanding and expectation that a Bill of Rights would be quickly added. So states were saying, listen, we like it, we're kind of okay with it, we'd like to see a Bill of Rights. I know you're working on it, but let's get these things down so we can vote on it. The first Congress accordingly proposed 12 amendments, 10 of which were ratified by the requisite number of states and became the Bill of Rights. So there were 12, like I said, and then only 10 were ratified. The last of these first 10 amendments addressing the Federalist concern that a list of rights might imply the federal government had powers. The 10th Amendment thus served to allay fears that the new national government might seek to exercise power not already granted, and that states might not be able to exercise fully their reserved powers. So people were saying, you know, hey, you got this power, and you know, once you got power, what stops you from grabbing more power? And the 10th Amendment addressed it. Unlike the analogous provision in the Articles of Confederation, both houses of Congress refused to insert words expressly, the word expressly before the word delegated in the 10th Amendment. James Madison's remarks during the congressional debate on the amendment are also notable. Interference with the power of the states was no constitutional gradation of the power of Congress, meaning that Congress would not interfere in states. It's federal. But Article 5 states that federal law is supremacy across the land. If the power was not given, Congress could not exercise it. If given, they might exercise it, although it should interfere with the laws or even constitution of the states. This was the conflict. What happens if my laws interfere with yours? And that was why Article 5 addressed that. And the summary was the reservation in the 10th Amendment eliminates any possibility of power of the legislators to adopt amendments granting to the national government any additional powers over the people. The whole great struggle over the adoption of the Constitution, save only in Rhode Island and questionably in New York, was not over whether a national government, a more perfect union, should be created. They all agreed that's what they wanted to do, but over whether the Constitution as proposed should be adopted without first being amended so as to provide expressly that the new government should have no power to acquire additional powers over the people or their rights beyond those expressed conferred on it by the original instrument. So you couldn't add a tag along in it. This is it. Without the express consent of the people. It was only by public promise that such amendments would be made that adoption by the people of the requisite 9 states was secured. Although it was generally then assumed that the power of the amendment was limited by the terms of the preamble, the importance of express limitations of the power of the amendment so that no other construction could ever be placed on it was specifically asserted. Then go, hey, all right, we're going to do this, but understood right now, everyone in the room, this is not going to evolve into a bigger bite that the federal government can have. The first 10 amendments were adopted for the express purpose of safeguarding the people forever in these respects, meaning that you ain't changing nothing here. They're staying exactly what they are. You're not changing a word. You're not changing nothing. You're not adding to it, and you're not taking away from it. And that's why I said the Bill of Rights in the first 10 amendments are forever. And that's what the 10th Amendment kind of locked in. And this is why people who then scream, we want to do away with the Second Amendment. You can't. You'd have to get rid of the 10th Amendment first. So you think about that. To change wording, to add limitations, to make those 10 amendments, I almost call them commandments, to make those 10 amendments less or more, you'd have to get rid of the 10th Amendment, which then could unleash ultimate power. The 10th Amendment sealed, forever sealed, the Bill of Rights. So, and no one can unseal that without taking away the 10th Amendment. And you go, well, how could you take away the 10th Amendment? You said you can't do that. And I would argue that even under Article 6, which allows for the repeal and amendment, you might be able to do that with the 11th, 12th, 13th, 14th, and everyone up the scale. Because the 10th Amendment didn't mention that. So, what our forefathers said with the 10th Amendment is no further. It stops here. And what is written and what is approved shall be forever. Very powerful. And that's where, I said, that pesky 10th Amendment gets in the way of a lot of things. And it was primarily drafted by James Madison, who introduced it to in Congress. Again, I went through this with reassuring that the new federal government's powers were limited. So, that's it in a nutshell, the 10th Amendment. Now, craziness that's going on with people using the 10th Amendment, and the 10th Amendment had been used in, cases from like 1920 all the way now into 2026, where there's articles where there's litigation pending on the president's authority to send troops in when the state won't abide by federal law. And again, in the 10th Amendment, it really does state in there that resources, and it doesn't state in there, it's been said by the Supreme Court that resources to allow the states can't be forced or compelled to use law enforcement to in effect do the job that the federal government should do. And this is IRS, FBI, Department of Justice, so many, including ICE. And the argument being made by Illinois and the argument made by Minnesota that, the agents are being flooded in there. Well, there's no limitation. It doesn't say you can't send in 100 agents, or you can't send in 2 agents, or there is no limitation. The idea is, can I send them? The answer is yes. The answer is yes. The president can send federal agents into any state for any reason to carry out the business of the federal government if said state does not agree to do that job for them. And they don't have to. And they didn't want to be compelled. They didn't want to be forced to. We'll do it voluntarily, but we don't want it to be forced upon us. If we feel so strongly that, one, we can't do it, we don't have the resources, or 2, we find that it's a federal, that's your business. That's not part of our business, the state's business. But what the states can't do is tell the federal government you can't send them in. And inside the state's own constitution, they provide for protection of citizens and those persons inside the state. Well, ICE agents are in the state. And the local government has to provide protection. If the local government cannot, the state must provide protection. If the state's law enforcement are unable or unwilling, then the governor has to call out the National Guard to do it. If the National Guard is not called out and the governor is saying, I won't do it, then the president is allowed to send in his own National Guards. And this is what people don't understand. And yeah, do you want to have to do that? No, I don't want to have to do that. Now, when that happens, under the 10th Amendment, they said, well, you could stop all federal funding. as a means to entice them to at least do the minimum that they're required to do. Now, you could have them like this, and in Chicago, we're doing it. We're handing them over to ICE. We're doing this, but we're not going to arrest them, unless you have a legal warrant. Now, a civil warrant is different than a criminal warrant. One is an administrative warrant, and one is a judicial warrant. I would say that if you had a judicial warrant for the arrest of someone, known criminal, boom, boom, yeah, they'll assist you in it. If you have an administrative one, we'll get to it. Now, if they won't get to it, federal agents can do it. If federal agents are then attacked, the local police have to protect those agents. If federal buildings are being firebombed, and the police go, we're not going to intervene with that, well, then the federal government can step in to protect the property rights and, of said building and people. The idea that you think that, no, we don't want ICE. We don't need ICE here. We're a sanctuary city. There's no such thing as a sanctuary city. You can't have a law. You can't make a regulation that supersedes federal law. It's the law of the land. You just can't do it. So what did they do? What did the Democrats do? We will call them parolees. There's no such thing as parolees. You either had TPS and you gave them TPS, and then when they showed that none of these people had, true reasons, and we're going to remove TPS because it's temporary protection status, and let's hear from them. And then they don't come and they don't show, and you say, hey, you have to report back here, and they're hiding because they will be deported in most cases. And very cleverly, the Democrats knew that the pesky Fourth Amendment would get in the way, because how do you quantify if someone's here legally if you don't know who's here? Well, you got to start asking people. Oh, you can't stop people. That's against the law. That's profiling. Very clever. But this is going to come back and bite them. It's going to come back and bite the Democrats. The other thing that I saw today, Democrats are now ratcheting up. We're going to impeach the president before the midterms. And there's a lot of Democrats going, no, we don't want to do that. And Trump now is saying, hey, if the Democrats get in, they're going to impeach me. And you voted for a 4-year president, not a 2-year president. And I'm trying to clean up all this corruption. And you want an economy. Well, we can't have this economy if I'm spending $1 trillion over here in fraud. Allegedly $250 billion in California alone. $9+ billion that they know about in Minnesota. How many billions in Illinois, in Wisconsin, in Colorado, in South Carolina? Because we don't know what we don't know. And we're not allowed to go look for it. Is that ridiculous? And who's stopping us? The Democrats. They're stopping us from verifying numbers. And they think they're going to win the election. Do you realize what's going to happen? Once ad campaigns start. And they'll start in March in earnest. This person, boom, 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 won't let us look. Why? Why? And you'll have the Democrat. Trump wouldn't show his taxes. He doesn't have to show his taxes. That has nothing to do with fraud. The IRS looked at him and gave him a thumbs up. We're finding fraud over here. So that's going to be my next show. Now, due to situations that are going on, I might not have a show for the next week or so. Sorry, that's just the way it is. These are circumstances of a very personal nature, and I just won't be able to do it. If tomorrow I can do a show, I'll do a show tomorrow, and I'll try to incorporate a couple of shows in to be automatic release during Monday, Tuesday, Wednesday, Thursday, and possibly Friday of next week. There'll be 15, 20, 30-minute shows, and that's it, but they'll go out. I will not do a live show like I'm doing right now. This is live and going out. So, and, this is going out. No one's watching, but it does get recorded and stays as what I always call a safety record in case my switcher acts hinky. Okay, with that, it's almost 40 minutes of this. I hope anyone that had questions on the 10th Amendment, I answered some of those. And it's a very powerful amendment, but it works both ways. So, Bob in New York, I am sure you're going to be asking me questions and debating what I have said. And I will have to point you to exactly where I got my information from. All right. With that, please give to a charity if you can. If you don't feel like doing that, please give to a food bank. They need food and they need monetary contributions. Please say a prayer. Prayer does work, no matter what a Democrat tells you. And with that, I'm going to be fading to black.